Good morning, Lord Mulholland. Will you take the oath?
Yes,
Just remain seated. I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Graham.
Thank you. Good morning.
Morning.
You are Frank Mulholland.
I am.
What age are you?
65 last week.
You are a Senator of the College of Justice.
I am.
And for the public listening, that means you're a judge who sits in the High Court in the Court of Session.
Yep.
And you were Lord Advocate from May 2011 until around May 2016.
Yep.
And in that capacity, you were involved in the investigation into the death of Mr. Bile.
Yes.
At the point in time when you left the role of Lord Advocate, I think that was shortly prior to the final PERC report having been received by Crown Office.
Yep. Although I wasn't there when it was received. There was an interim report, I think, had been submitted
So
whilst I was in office.
You'd received the interim or the first report from PERC, but you were not in office when the final report was received. Thank you. And you were not involved with the arrangements that were in place after the final PERC report was received, allocating the team or the advocate deputy?
No, that was someone, that was Successor and
that was
Crown
James
Office.
Wolfe.
Yeah, yeah.
And James Wolfe was your successor?
He was.
Thank you. Have you had any chance to watch any evidence in the inquiry at all?
No, I decided not to read any other witnesses' statements, and I decided not to see or view any of the evidence.
Well, in that case, let me tell you about the blue folder that's sitting in front of you.
Yeah.
That provides you with hard copies of your inquiry statements, and you can use them as you wish. And if there's anything you'd like to refer us to within your statement, please let me know and we can have it brought up on the screen.
Okay,
When
thank
I
you.
ask you specific questions, about your statement, it'll come up on the screen so that everyone in the room can see, but it'll only show a paragraph or perhaps two. But if there's other areas you'd like me to refer to, please feel free to tell us. And equally, if there are any documents that you feel you should see, which I've not let you look at or not provided you with, please let us know and we'll try and get them at the next break.
I gave the witness support person the number of 2 documents.
Well, I will have a look at those in the break and we can deal with them, unless I'm already going to speak to you about them.
Yep.
Thank you. Could we start, first of all, with your first inquiry statement, which was from March, which is SBPI 00476, I believe. And as you'll see, that's come up on the screen. You'll recognise that as your statement for the inquiry.
I do.
And if we look at the final page, there's 22 pages. If we look at the final one, you'll see it's dated. It's been signed, although the copy we see on the screen is redacted. But I'm correct in saying it's signed on the 11th of March 2024.
Yep.
And the final paragraph we see on the screen, 126, reads, I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website.
I'm aware of that.
Thank you. And you were doing your best to give a true and accurate recollection of your involvement when you gave the statement.
Yes.
Then with the second inquiry statement, SBPI 00536. And again, this was taken by the inquiry team in April, 5th of April 2024. It's 7 pages long, and if we can look at the final page, we should see that, as I understand it, you signed this on the 15th of April 2024. There we are, at the bottom.
Yes.
And again, if we look at the final paragraph, it's the same wording, paragraph 32, that you believe the facts stated in this statement are true, and you understand this statement may form part of the evidence before the inquiry and be published on the inquiry's website.
Yes.
Thank you. And again, you were doing your best to give a true and accurate recollection of your involvement. Could I begin by asking you about the topic of disclosure? And there's two aspects to this I'm interested in. So this is in relation to your involvement as Lord Advocate and the disclosure that you gave to the family.
Yes,
And we've heard that they were represented by their solicitor, Mr. Amar Anwar.
yes.
Perhaps we could look at, there is a paragraph in your own statement, paragraph 94 in the first statement, which touches on disclosure. But I have some additional questions. You talk about not being aware of any undertakings and promises made by you beyond the general one. This is to the family, that the inquiry would be thorough, that the issue of possible racial motivation would be investigated, that I would continue to meet with the family, and the Crown would not make any public statement on the investigation. Looking behind that aspect of it, we understand from other evidence that we've heard that you authorised disclosure of material available to the Crown to the family through their solicitor.
To their solicitor, yep.
And as I understand it, that a number of documents were disclosed on your authority, and you also permitted them to watch CCTV of the events at Hayfield Road. As part of that, did you require Mr. Anwar to sign any formal undertaking or disclosure or confidentiality agreement in relation to that disclosure that you authorised?
No, but I mean, there's a background to it. I've worked or been involved in cases in which Mr. Anwar has represented families over the years. For example, I prosecuted the murder of a Scottish Asian lad called Imran Khan. He was murdered in Pollokshaws in Glasgow, and that's the first time I came across Mr. Amar, who represented the family of the young lad. And there was issues about the mother, didn't speak very good English. And that's when I got to know Mr. Amar, who assisted in liaison with the family in that case. I also did work on the Chokar case after the collapse of the first two trials, and Mr. Amar represented the family. And I again ensured that, as Lord Advocate, that this was given top priority through the cold case unit and required to be a liaison with the family. I remember going out to speak to Mr. Chokar's family with Mr. Amar Anwar, who assisted, and the liaison with the family to ensure that they were told and advised of what the process was, leading to a double jeopardy application and a successful prosecution in that case. I also worked with Mr. Amar in the murder of Emma Caldwell, which was sent to the cold case unit when I was Lord Advocate. And I liaised with Margaret Caldwell with the assistance of Mr. Amar Anwar in that case. So there's been a lot of very high profile, very important, very difficult cases for the families to navigate through. And I worked with Mr. Anwar on these three big inquiries, big cases. So I trust Mr. Anwar. He has never breached any confidentiality that any information that I've given him. And he, of course, has his duties as a solicitor. And it seemed to me that there's an Article 2 right for effective participation by the family. The source of that is paragraph 435 of Human Rights in Scotland, edited by Robert Reid, Lord Reid, the chair of the Supreme Court, and Jim Murdoch. And that explains the Article 2 rights, that there requires to be effective participation by the family which I was well aware of and did my best to ensure. So it seemed to me that it was important because the family are going to do, the solicitors for the family are going to do their own investigations. It was a mandatory fatal accident inquiry at the very least. So what I wanted to do was to ensure that he had the material to instruct his own experts, and part of my obligation in terms of Article 2, effective participation, was to explain the process to the family, listen to their concerns, listen to any points that they want to make, answer them if I could, and ensure that they were participants in the process. So that was part of that. So, and give you a wider aspect on disclosure. I led the Crown through two Supreme Court disclosure cases. I argued them myself. I wrote the disclosure manual for the Crown with the late John Dunn and John Watt, who now heads the parole board. And I also have done a number of appeals in the appeal court in Edinburgh on disclosure matters. So, applying all that knowledge, experience, judgment, I determined that I would disclose matters to Mr. Anwar so that he can conduct his own inquiries, and that's participation for the family. So that's the background to it.
Thank you very much. Did you have any concerns against this background that you've explained of risks to future criminal proceedings in the event that you made this disclosure?
Well, I thought about it. I mean, I just didn't make it in a vacuum, that decision. I thought about it. Firstly, there's a statutory inquiry inevitable, right? So there's preparation required by the family's legal representatives. Secondly, in relation to the potential criminal proceedings, I could not see how that would prejudice any potential criminal proceedings. The family, a lot of the family lived in London. They were not witnesses, or wouldn't be witnesses. I couldn't see how they could be witnesses. Colette Bell lived in Fife, and there was some family and friends in Fife. But Colette Bell would be a witness to background as far as I could see it. She wouldn't be a witness to fact, in other words, what went on that resulted in Sheku Bayou's death. So, applying my judgment, I took the view that I couldn't see the risk to potential criminal proceedings was very, very small.
Thank you. We have heard evidence from James Wolfe, who was your successor, and we've heard about the differences in approach that were taken by you in relation to disclosure and by Mr. Wolfe. And I'd like to ask you about some of his evidence so that you can comment on that. Perhaps if we could have his inquiry statement on the screen, SBPI 00529. There's 3 or 4 paragraphs of relevance, and what I'll do is I'll briefly look at those on the screen, and then we can discuss his evidence together. Paragraph 60, please. And it's just after when the issue arose in the context of further detailed disclosure requested by Mr. Anwar in February and March 2017. So this is after you'd left the role of Lord Advocate and James Wolfe had taken office. I was presented with a dilemma. On the one hand, it would have been contrary to my own experience of Crown practice for disclosure of the sort requested to be made in the context of a live criminal investigation. That general practice reflected a compelling public interest in avoiding any risk of prejudice to future criminal proceedings. On the other hand, in this case, Mr. Bio's family had already been given certain disclosure and were now seeking further disclosure. Mr. McGowan's advice in paragraphs referred to in a minute and an email was consistent with my own experience. I also recall having a brief discussion with the APCC Assistant Principal Crown Counsel about the issue. I'll briefly let you see the minute that he's referring to, SBPI 00529. Oh, sorry, that's a statement. It must be COPFS 00529, I think.
So is this a Steve McGowan?
Yes. We'll leave this, I've got the wrong reference there. I don't want to cause difficulty. Having read the minute and having discussed it with Mr. Wolfe, we can see that advice was given to him in relation to disclosure by Mr. McGowan. Let's move on to 61, which is on the screen. I took the view that my overriding responsibility at that stage was to avoid any risk to the integrity of criminal proceedings should they eventuate. It would neither be in the interest of Mr. Bio's family nor in the public interest if disclosure of information by the Crown, whilst the investigation was pending, were to prejudice a future prosecution. I also had to be mindful that if information were to be disclosed to the family in this case, issues would likely arise in other death cases to which Article 2 applied about the disclosure of similar information whilst an investigation was ongoing. And then moving on to 62. I considered whether the investigative obligation under Article 2 of the European Convention on Human Rights required a different approach to be taken and took the view that it did not. It seemed to me that the question of compliance with the UK with its obligations under Article 2 failed to be addressed in light of the whole process of investigation and inquiry which could be anticipated. I expected the position in relation to disclosure to be different in the context of an FAI or indeed a public inquiry once any issue of criminal proceedings had been resolved. Not only would the family of the deceased see the evidence being led at the inquiry, but they would likely be represented and would receive disclosure in that context. I accordingly concluded that further material should not be disclosed, where that disclosure presented a risk of prejudice to future criminal proceedings. As regards the specifics of what information could safely be disclosed without a risk of prejudice to future criminal proceedings, I relied on the judgment of the professional prosecutors directly involved in the case. So let's go back to 60 first of all. And you'll see that this was, he describes it as a dilemma, and he talks about his general practice, Crown practice for disclosure at that time. This was in the context where the final PERC report had been received and the process of Crown recognition was underway. And the issue was whether to give the family further disclosure at that stage.
What was asked? What was the request, or what disclosure?
We'll have to see if I can get... I think the difficulty will be I don't have the access to the minutes on the screen at the moment. My understanding of the position is that further disclosure of expert reports was specifically requested, and my reading of the minute, which we can't see at the moment, is that that was specifically raised by Mr. McGowan, the request for expert reports.
Well, without knowing in detail what the actual request was and what the reason for it, it's kind of difficult to comment on the specifics. I would just make a general observation. It's very easy to say, well, I can't give you it because there's a risk of prejudice to future criminal proceedings. I think you've got to drill down and well, what is the risk? And what I'm saying to you is when I took the decision, which I stand by, I think it was the right decision with the benefit of hindsight. I drilled down to look at, well, what is the risk of prejudice and what was the purpose that this disclosure, when I dealt with the matter, what was the purpose of this request? And as I understood it, it was in relation to families instructing their own experts and their own inquiry. So it seemed to me that it was consistent with my obligations in Article 2. I couldn't see what the risk was, and James Wolfe's statement, he's not articulated what the risk was. As I said, I couldn't see that information being prejudicial for the family that lived in London. They were not going to be witnesses. And in relation to Colette Bell, she was not a witness to what happened. So I took the view, and as I say, I stand by it, that the risk to future criminal proceedings was very low.
Thank you.
And also you have the duties of a solicitor as well.
Right.
Obligations of a solicitor and ethics.
The evidence we heard from Mr. Wolfe on the 1st of May yesterday was that he had taken the view that Article 2, or he had been told that a view had been taken that Article 2 required disclosure, but he was not convinced that that was correct in the context of a criminal investigation. Do you wish to comment on that?
I disagree with him.
And he gave evidence that the Crown had a responsibility and needed to be able to investigate, as it were, in a private space and to reach its conclusions and then take whatever course was the right course.
Well, I agree with that the Crown needed to do its work in a private space. I mean, I issued the one and only time in my time as a law officer, I was 9 years a law officer, a media release saying that the Crown wouldn't make any public statement, that all the stories in the press were upsetting for the family, and asking the media to essentially stop it or report responsibly. So obviously you need to conduct your inquiries, the Crown, in a space that you can do that. But I mean, the Crown's got loads of experience in dealing with high-profile investigations and prosecutions, and not being affected by outside noise, for want of a better phrase.
Thank you. I have been provided with the minute I was looking for earlier, COPFS 03943A. It's not on the playlist. If you don't mind, I'll read out an excerpt
This is
just to complete
Stephen
this.
McGowan's
This
minute.
is the minute dated the 7th of February 2017 from Stephen McGowan to the then Lord Advocate and others. And I will read out from paragraph 11. Throughout the course of the Perk investigation, the family and their solicitor received disclosure of information reflecting their rights under Article 2 in order to facilitate the instruction of their own expert witness or witnesses. 12. It is clear, however, that following receipt of the report by Perk, that the focus and direction of this investigation, which remains a live criminal investigation, has now passed to the Crown. Given that precognitions are confidential, our advice is that we should not share the detail of what we have learned or the precognitions themselves. Our investigation at this stage should remain confidential, and there is a real likelihood that a number of family members are potential witnesses in any future proceedings. In light of this, it will be important that the expectations of the family and their solicitor, particularly regarding disclosure at this stage, should be carefully managed. And then 13, similarly, whilst we have thus far shared expert reports with the family, We do not recommend sharing the new reports that we are instructing at this stage. And there's a reference to paragraph 5 above, which details a number of expert reports that were being instructed at that stage, including an osteoarticular pathology report and a further expert pathology report. So I'm sorry that I can't show you that
No,
on the
that's fine.
screen,
I
but,
get the gist of that. I mean, what I would comment is that Ms McGowan and James Wolfe are dealing with a different situation. The final report's in and the Crown's now doing its precondition preparation. When I made the decision, it was a different set of circumstances, and I took the view, and as I've said, I stand by. I think it was the right decision. And I just make a general observation in my time as a law officer, is that you are given advice on a regular basis by permanent members of staff in COPFS. I know Mr McGowan, I know him personally. I have a high regard of his abilities. But the advice you get is not always right. And at the end of the day, it is the Lord Advocate or whoever's taking the decision, could be Crown Counsel, Senior Crown Counsel in those circumstances. That is the decision maker, and regardless of what the advice is, it is the person that's got to make the decision. So, but it's a different set of circumstances, it seems to me, from the excerpts you've read from Mr McGowan. Thank you.
And then another aspect of the evidence we heard from James Wolfe yesterday, it was, he said one risk in the context of a possible criminal prosecution of the police officers is the question of, you know, the Crown has to be independent and demonstrably independent. One would not want to end up with a position where it could be said or any issue could be raised about the, as it were, the independence of the Crown investigation, regardless of how that might have been affected. And did you consider, when you were dealing with the matter, the issue of Crown independence?
Of course. I consider Crown independence all the time to ensure, it was a frequent mantra from me on a whole raft of cases about Crown independence. In my time as Lord Advocate, very unpopular decisions were taken in certain cases, commensurate with the Crown's independence. And it might be helpful if at one stage bring up a letter I wrote to Pamela Payton, who was the wife of, is it Alan Payton, Constable Alan Payton?
Yes, we've heard evidence.
Yeah, well, she was upset at a lot of the media reports and about what had happened and who was saying what. And she emailed I don't have access to the email, but I responded to her with a letter of 2 pages, which I set out in great detail the Crown's obligations, and I explained that liaising with the family, meeting with the family is not in any way an indication that the Crown was representing any one particular party in this, and I explained what the Crown's obligations were in relation to Sheikh Ubayu's family. So what you have, I mean, if you cannot shut the Crown down from speaking to people affected by investigation, case and decisions. That is not a breach of your independence as a decision maker, as a prosecutor. You have to speak to people and listen to what they've got to say. That doesn't affect your independence. No, as far as I can see, no one ever suggested that to me that the Crown weren't independent in its investigations into the death of Sheikh Ubayu, so it was considered considered all the time, the whole raft of cases.
I believe the letter has been added now, COPFS 04836A, and this may be the letter that you're referring to.
It might be quite helpful if I could have that on screen, just to go through
Yes.
it, please.
I've just asked for that to be. It'll just take a moment, I think. So it's COPFS 04836A. This is a letter from you, the Right Honourable Frank Mulholland QC. And if we can move down, and it says PC Payton's wife.
Yeah, that's
14th October 2015.
That's the one. There was an email that came into the private office, and I think if you just scroll down, I think she was upset, amongst other things, at something that Les Brown had said to her in a phone call. So I wanted to set out what the Crown's position in this was. As you'll see from the second paragraph, I state that the investigation into the death of Sheku Bayo is at the instance of me, who is statutorily responsible for the investigation of all deaths in Scotland. Investigation conducted by PIRC, who act under my directions and superintendents. I set out what the decisions at the end of the day required to be taken. I state emphatically that Lord Advocate is impartial and will take decisions following a full and thorough investigation. The Crown has a long and proud history of conducting impartial investigations, and this one will be no different. Please do not think that because the family of Sheku Bayo are involved in the process, that impartiality is compromised. They will not be involved in the decisions, which is right, but have a legal right to be kept advised of progress in an investigation of this nature. It is important that the family have confidence in the process, so that they can have confidence that decisions taken are taken following a full and thorough investigation, and that the family understand why the decisions were taken. Family are not being treated any differently than other families in similar circumstances. If we can go on to the next page, please. I'm sure you will agree that all parties affected by this decision, including the police officers involved, should have confidence that decisions were taken following a full and thorough investigation with expert opinion from the most eminent experts available. Appreciate the amount of publicity this case has generated, and that this has been difficult for the persons affected. Should note that the Crown has not been responsible for the publicity, and I've said very little about the case other than to talk about the process. I have not and will not talk publicly about the evidence, as to do so would be tantamount to prejudicing the investigation before it's completed. I hope that at the end of the process, you will have the answers you and all parties affected seek. I then go on to deal with what she was saying in relation to Les Brown. And she was also, I think in her email, she was upset about a BBC documentary. It was due to be broadcast, and I explained that I can't prevent the broadcasting of that, but any matters which are raised in the documentary which will be thoroughly investigated.
Thank
what
you.
I said. So that sets out what the Crown position is in independence, and that, as I said, liaising and speaking to families of deceased persons affected by this is not in any way compromising your independence.
So when you considered the obligations under Article 2, but also the importance of retaining Crown independence, you resolved it in this way, and this letter reflects your thought processes.
Yeah, and I would just add to that Article 2 requires an independent investigation. Mm-hmm. So there are procedural requirements, and one of them is effective participation. And I remember checking, as I dealt with a number of cases over the years, deaths they call them at the hands of the state, as you know, but death in custody is another way of phrasing it. So when I became aware of Shiku Bayou's death, I checked the books
Thank you.
and
There
our
was-
Article 2 obligations.
Thank you. There was only one other aspect that we heard in evidence from James Wolfe, and that was his evidence that, let's say, one went to a position of very open disclosure to any party. And let's take it away from this case, taking views about how the Crown should proceed with its investigation and so on and so forth. Issues about how that would be perceived down the line in the context, but he also talks about a concern, or he gave evidence about a concern regarding putting himself or the Crown under pressure to make similar disclosures in other cases also. Did you
Well-
have any concerns about in that regard?
No, what I did was I looked at the circumstances of this case, and I applied my mind to what is the prejudice. It's very easy, it seems to me, to hide behind, well, it could be prejudicial. I think you've got a duty to drill down and try and identify what the potential prejudice is. And when I did that and give consideration to that, as I've said, I think there was a very small risk. So I took the view that it was appropriate in those circumstances for the reasons that was been asked to disclose, in other words, to instruct experts and the duties and obligations of a solicitor. My past experience of Amer Anwar, it never breached the confidentiality. When me speaking to him speaking to me, it seemed to me that I should instruct the disclosure for that to happen, which I did. It's a different situation when the Crown's doing their investigations and it's being recognised after the full reports come in from PERC. So it's a different set of circumstances. But I'm the Lord Advocate. It's up to me to make a decision. I thought about it. I thought about it in depth, and that's a decision I took, and I stand by it.
Thank you. We've heard that the different approaches had an impact on the family, and I'm interested in your perspective about the benefits of your approach in relation to building trust and confidence in the family.
Well, I've been a frontline prosecutor in the High Court as an advocate depute, as a senior advocate depute, for what, 10 years. In my work as a member of COPFS in senior positions, I've met families in very difficult situations for them. To give you an example, the day after the collapse of the World's End trial, I was asked to go in and meet the families. As you can imagine, that was a very, very difficult conversation. So I have experience of those difficult conversations and helping families through very traumatic, troubled, upsetting, distressing times. My approach is always, I mean, for example, I was involved in, as Lord Advocate, in the Lockerbie case. I went out to Washington to speak to families at Arlington on the anniversary. So I've got experience in that. I dealt with the Chokar families. I also dealt with the murder of Elaine Doyle, a young girl that was murdered in Greenock, and it was, I think, over 25 years before the perpetrator was brought to justice. I dealt with very much under the radar, confidential, speaking to Mrs. Doyle and Mrs. Doyle's family and her husband who passed away before. So what I'm saying is I've got lengthy experience, probably more experience at the time I was Lord Advocate than anyone in the Crown in dealing with families in these types of situations. What are the benefits of it? Well, firstly, the benefit is it helps the families. They didn't ask to be put in this position. They didn't ask to have to or come up to Edinburgh and meet people. They were happy getting on with their lives in London and Fife. And then something happened that's propelled them into this alien situation that seemed to me that on a human level, on a professional level, it was important to speak to the families, to explain the process, to listen to them, listen to their concerns, answer any questions that they have, if I could answer them at that time, and involve them in the process, effective participation, which is required in law. That's my approach, and throughout my lengthy legal career, that's what I've done, and again, I stand by that. I think that is the right approach. Let me tell you, in my experience with the family of Sheku Bayou, they were a nice family, put into this position. They were not, and I had a number of meetings with them. They were not looking for revenge. They were not looking for someone to pay a price for this, regardless of their involvement. What they wanted was they wanted answers. They wanted to know what happened, why it happened, whether anyone is responsible for what happened, whether anything could have prevented the death of their partner, son, brother, and they wanted to be listened to. And it seemed to me that that was hugely important in this case. And the other thing you've got to remember is the background to this. You would need to be deaf not to know of the difficulties that the Stephen Lawrence murder had and caused, and the loss of public trust in the judicial process, prosecutorial process, the investigatory process. And in Chokar, it was quite clear from the two inquiries, the Jandu inquiry, which looked at how it was dealt with, the liaison with the family, and the Sir Anthony Campbell inquiry about the process, that the Crown had failed the Chokar family. And as Lord Advocate, I wasn't, I was going to do everything I could to prevent that happening under my watch, which is why I liaised, spoke to, listened to the family of Sheku Bayou. And again, I think that was the right thing to do, and I don't regret it. And if it happened tomorrow, I would do the same thing.
Thank you. I'd like to move on to the issue of race.
Yeah.
And you've discussed this in both statements. Perhaps if we could look at paragraph 6 of your statement, the reason I involved myself from the beginning of the investigation. Here we are. The reason I involved myself from the beginning of the investigation into the death of Sheku Bayou was in light of my experience of 30 years as a prosecutor. I have been involved in numerous high-profile and complex cases. I was not involved in the initial investigation into the death of Surjit Singh Chokar, but I dealt with the fallout from the case and the Jandu report, which concluded that Crown Office was institutionally racist. I prioritised this case for re-investigation and superintended the subsequent murder case through the double jeopardy application and trial. I was not going to let what happened in the Chokar case happen again with Sheku Bayou, namely poor liaison with the family, not addressing issues of colour, nor investigating racial motivations. And is that colour of his skin? If any, for that happened. That is why I became involved in at an early stage. And was that something you were immediately, you say at an early stage, was that something you were immediately conscious of
As soon as I heard about it, I knew from experience that this was going to be high profile, that issues of race, racial motivation were going to be front, left and centre in relation to the investigation. As a Lord Advocate, you're the leader of the prosecution service, and it would be an abrogation of my responsibility as Lord Advocate to leave that to someone else. It seemed to me that this is what I required to do, was to step up to the plate and superintend the case. I mean, I don't have the time to deal with the day-to-day goings on, but I needed to know about the case, about the circumstances. I also needed to know where the investigations were going, because it's very important in relation to resourcing the investigation, the inquiry, that I know where the investigation is at and what the issues are, because if additional resources were required, it's my job to get the money for it, to fund those additional inquiries. For example, in the Lockerbie case, one of the things I did was to get additional funding for investigation, and there are other cases where that's happened. So again, that was something which I needed to know, you know, whether they had sufficient resources. And I mean, it's stating the obvious that with the constraints in the public purse, you know, it can be a battle to get additional resources if they're required, and I need to know what the position is in relation to that.
At that stage, at that early stage, what were your expectations of the Crown and your staff, and how the investigation would be conducted? Well,
at the initial stage, is that it hadn't been over to the Crown yet, because the PERC final report was not in. So we're at that stage. I think there was an interim report which was submitted during my time. So the Crown was not at the stage of conducting its own investigation. So obviously I would give thought to that. What my view would be that it would require a very experienced and senior Crown Counsel, maybe at Principal Advocate Depute level, that the Crown Counsel appointed to the case would need to be supported with Assistant Crown Counsel. That given the importance of this, that the people in COPFS that were dealing with it would require to be experienced and have the ability and track record to be able to deal with cases of this importance and magnitude. There were complexities in this in relation to the pathological evidence, so you required an intellect to be able to navigate through that. There were also issues, other issues in the case about toxicology, about positional asphyxiation, a whole raft of issues that were not day-to-day issues that you would have to deal with. So my view was it would need to be prosecutors, I'm not talking about Crown Counsel, but permanent prosecutors in COPFS, who have the ability and experience to be able to undertake that. Now, Les Brown, I know Les Brown, know him very well, hold him in very high regard. I had no doubt about his experience and ability to be able to deal with that. So I was reassured that he was directing the investigation. I also knew that Lindsay Miller, who is another person I hold in high regard, had a role, a superintendent's role, and involvement in this. And I can't remember at this stage, there were others as well, but prior to meeting the family, I would have what's a briefing meeting, so I would have the key personnel down. I would discuss where we are, what the issues are, the questions that were raised by the family, have they been answered? What are the answers? What's your fears? What's your concerns? have we properly resourced this? So all that information would be flowing to me from them. And also there's a byproduct of that as well, in the sense that the staff, permanent staff who are dealing with this case know that they've got the Lord Advocate's support. And that is very, very important, because these are difficult cases to deal with. There are people of that calibre and dedication to public service who step up to the mark to be able to deal with these challenging and difficult cases, and they have to be supported as well. And that's what I was doing as Lord Advocate, so it's a two-way process.
Thank you. We've heard from Stephen McGowan in evidence, and perhaps we could put his inquiry statement on the screen, SPPI 00431. And if we look at paragraph 63, in my view, everyone was aware that race was a matter at the heart of this investigation. From the first telephone call I had from David Green to the question of the deceased race and whether it was a factor was discussed. No one was in any doubt that it was an issue. Whilst no specific instructions were given to consider race as a motive, my recollection was that it was clearly discussed at the time, and everyone involved was seized of the requirement to investigate the potential for race to have been a motive. Would you agree with that?
Entirely.
Right. And
I think I said something similar in my statement as well.
I think in paragraph 78 you say race was front and centre from the outset of the investigation. Yeah. A black man has died in police custody. It was obvious. In relation to the comment here that we have on the screen is mentions that no specific instructions were given to consider race as a motive. So we've looked in detail at the instructions that were given by the Crown to PERC when it came to the actual investigation into the death of Mr. Byle. And there were no specific references to race at that time. Was that something you were aware of?
No, it would probably be unnecessary, because race was an issue, left, front and centre. There's a letter which was sent by Les Brown. I gave the number to witness support. There's a Les Brown to John somebody, to John Mitchell of PERC. And there's a reference to, in that letter, if we could have the letter up, it may assist you.
Right. I'm advised that it is COPFS 06256.
Yeah, John Mitchell.
Is this is dated the 13th of January. Well, it says 2015.
It's wrong.
It must be 2016.
Yeah. So if we could just scroll down. So we're talking about the paragraph 1 when the final report is read the comments in relation to the respect of the allegation of racism in Fife Division, and note that some statistical analysis had been carried out, but would question whether the figure is indicative that institutional racism played no part in the approach of the officers to Sheku Bayou, as stated by John McSporn. I mean, the investigators went to they looked at complaints against the police for the various forces before it was amalgamated into Police Scotland. They drilled down into whether complaints were being made of racially prejudiced conduct by police officers, and they then compared that with similar complaints across the other police forces. So that's a seam of work which was important to be done, indicative of race being a key issue in the case. And it says the importance of ensuring that issues of race are fully addressed as part of the PERC investigations has been highlighted in our previous meetings. From a Crown perspective, your investigation has to consider whether race had any influence in the way that the incident was dealt with as part of a wider consideration, as well as whether there was any evidence of overt racism. Clearly, the latter will be explored as part of your investigations relating to Constable Payton. However, you'll no doubt recollect the discussions at our last meeting with the Lord Advocate, where your attention was drawn to the behaviour of I think it should be former as opposed to formal, Fife officer who appears to have been responsible for distributing racist communications and offensive images. So what I'm saying is that any information that would suggest or that could support racial motivation was passed on to PERC. It was front, left and centre at meetings with PERC. And Les Brown is clearly dealing with it and clearly knows it's a key issue and refers to discussions involving me in which these issues were being discussed. So to answer your question, if there was, is it section 33 direction?
33A.
33A, if that was not included in that, then it doesn't mean that race wasn't an issue. It clearly was from the very beginning.
We've heard evidence that a number of letters of instruction were sent, first of all under section 33A, by the Crown to PERC to formally instruct them to investigate the death of Mr. Bile. And that during that period, up to the end of August at least, there were no references to race as part of that instruction in correspondence from the Crown to PERC. And that during that period, PERC were, as we've heard evidence describe the situation as, they were taking cognizance of race if issues emerged, but they did not pursue any active lines of investigation in relation to race. Were you aware of that at the time?
I certainly wasn't aware of it at the time, and it would be inconsistent with the example of the work being undertaken by PERC to look at statistics and complaints against the police and that type of stuff and investigate. There was specific instructions given to PERC to investigate allegations that were being made against certain officers. So that seems to me to be inconsistent with what PERC were doing.
Explain that from the 2nd of September 2015, we've heard evidence that there was a letter from the Crown to PERC asking for confirmation that race was a priority in the investigation. And that was the first reference.
To who was that from?
That was a letter from Les Brown to PERC on the 2nd of September 2015. And that was the first reference in Crown correspondence to inviting confirmation that race was a priority in the investigation. From September onwards, that letter specifically instructed PERC to investigate issues that you've identified in this letter. The Fife officers' issues, history of racism, prior misconduct. So certainly from September 2015, there was reference to race in Crown correspondence and specific instructions given. But in the period prior to that, from the 3rd of May up to that specific letter, the PERC investigation had simply taken cognizance of race, but not, we've heard evidence, not actively pursued a line of investigation regarding race.
Well, I'm surprised to hear that.
Right. And were you aware of that at
No.
the time?
I find it surprising given, I mean, it's the interaction with PERC is not just letters. There's conversations and conversations with people involved in the investigation in PERC and Kate Frame, who headed PERC at the time. It was quite clear in the conversations that certainly I was party to, that race was front, left and centre.
So, and we've heard that you had a number of meetings.
Yeah.
You had a meeting with Kate Frame and John Mitchell from PERC on the 14th of May 2015. As far as you're concerned, in your communications with PERC, did you effectively communicate that race was a priority in this investigation?
I mean, it was weaved into the conversations. I'd be astonished if...
Obtained, but we've heard evidence that that was really the first point at which the matter became a more active line of investigation.
Well, I mean, you're telling me something that I wasn't involved in, but race was front, left and centre from the very beginning as far as I was concerned, and that occurred in conversations. Now, Amer Anwar is well entitled to formalise it and put it in a letter. He's quite right to do so. But that doesn't mean that this wasn't under consideration from the very beginning. As Lord Advocate, I knew. I dealt with Choka. I dealt with a number of what's under the broad umbrella of hate crime. I was involved in, when at the Crown Office, in the murder of Mark Scott, who was a young lad that walked through Bridgeton and was murdered just because he was wearing a green scarf. So it's not just race for me, right across the board. It seemed to me that that was something which I was a particular priority to me.
Can we look at paragraph 169 of your first inquiry statement? And I think you emphasise here the significance of race as far as you were concerned. 169 says the question of race doesn't seem to be the correct reference. Let's leave that to one side. Can I ask you, given the significance of race to you and the experience you had in that, and you've commented about race and racial motivation being important aspects of this investigation, what were your expectations of PERC during this period from the 3rd of May 2015 up to 2nd of September 2015 at least, that initial period?
Well, they would be conducting an inquiry. They were the investigators. They would report the results of that inquiry to the Crown when those investigations were complete. I mean, what my expectations would be, it would be a thorough investigation. It would be an investigation dealing with all of the issues in the case, including race. It would deal with the issues about the cause of death. It would instruct or obtain expert evidence from a raft of experts in their field, and that they would report the results of their inquiries together with their analysis, recommendations in our final report to the Crown.
In relation to race, did you expect PERC to not simply identify overt examples of racism if they existed, but to look at underlying references that may be indicative of racism or racial motivation? Of
course.
To consider...
I mean, that's part of the work that they did in the statistical analysis. I mean, PERC was it was a fairly new organisation. It used to be complaints or criminal complaints against the police. So it was their own forces that dealt with that. So they had criminal complaints against the police department in each of the police forces. Then, of course, you had Police Scotland, and that resulted in having to set up PERC so that there's an independent investigators, independent from the police, looking at Article 2 requirements as well. That was required. It used to be stated that, well, the independence comes from the involvement of the Crown, so albeit it's investigated by police officers of the same force, at the end of the day, it's going to be the Crown that ultimately investigates and takes a decision. So that was the prevailing view at the time, but of course things move on, and with the advent of Police Scotland, it was decided, and I think it was the right decision, to set up an independent body, and that's how PERC came into being. But Kate Frame used to head the criminal complaints against the police department at the Crown Office before she left to be head of PERC. So she had great experience in dealing with these types of cases.
Thank you. Did you, in terms of your expectation of Crown Office, and to some extent PERC, did you expect them to consider whether Mr. Bio had been treated differently by the officers because he was black?
Oh, of course. It's all part of it.
We've talked about Article 2. Were you, given your experience in relation to race, were you also conscious of the obligations on PERC and the Crown in relation to Article 14 in conjunction with
Well,
Article 2?
Article 14, you require an Article 2 or some other article obligation before Article 14 kicks in. But I was well aware of that. I think it's in my statement as well. Because I set out what the case law convention jurisprudence is in this area and what the obligations are on the investigatory agency, PERC and the Crown.
And we've heard that in terms of Article 14 in conjunction with Article 2, that both the Crown and PERC would have the duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice might have played a role. Would you agree with that?
Absolutely. I think I'd refer to it in my first statement.
I think paragraph 33 may contain that. There we are.
Well, there it is.
And when you say take all reasonable steps to unmask any racist motive, how did that translate to your expectations of PERC's role? How would you have expected them, what steps would you have expected them to take?
Well, the overarching is to carry out that obligation as part of the investigation. What steps? Well, I mean, that's for the investigators to identify what steps to discharge that obligation. But what they need to do is they need to investigate it uphill and down dale to identify or rule out any racist motive. And that is overt or covert in the sense of unconscious prejudice, racial prejudice, that type of thing.
So if we have heard evidence that there was language used within the statements of the officers referring to Mr. Bio as coloured, making connections or possible links between the colour of his skin and terrorism, matters of that sort, the use perhaps in the surrounding circumstances of racial tropes or racially stereotypical language, of detrimental, derogatory comments regarding black people, or possibly to be interpreted in that way. Are these the types of adminicals of evidence that you would have expected PERC to be identifying and considering?
Absolutely. You know, use of language is important. and that can identify an issue in relation to the wrong use of language. It can display a mindset, what the mindset is. And language is important, and that's one of the things that we looked at when I chaired the diversity group at the Crown Office when I was Lord Advocate, to look at the language used. I mean, I grew up in the 70s, and some of the language used that was part of the everyday vocabulary of people, you're looking back in 2024, you'd be horrified. Some of the programmes that were broadcast in the 70s, under the guise of comedy, you look back, you're horrified at it. So it's important. And I mean, people always say, well, it's freedom of speech. Well, it might be freedom of speech, but if you're on the receiving end of it, it's not freedom of speech to the person on the receiving end. So language is important. And language, the use of language and the wrong use of language can give an insight into person's mindset and motivation.
And for those listening, can you explain why is evidence that would relate to mindset or motivation be of value to the Crown in the job that the Crown are doing?
Well, it'd be, I mean, I make the general point that I was away at the time, that I'd stepped down at the time, that the final report and the work that the Crown did and what the evidence was when the Crown were preparing a case. So I'm really talking about this at a sort of overarching level. But for example, I think you referred to terrorist.
Yeah.
Well, I make a very obvious point. Would the mindset be, if it was a white person, would that person be referred to as a terrorist? So what I'm saying is these language, use of language, the wrong use of language can be revealing sometimes and deserved of investigation.
Thank you. And moving away from language at the moment, would you also have expectations that PERC initially would consider perhaps patterns of behaviour, underlying patterns, whether they'd use sprays or batons at other knife incidents, for example, or only in relation to this particular incident? Would you have considered it a relevant line of inquiry to look into whether they treated all knife calls as potentially terrorist related?
Of course, an example I gave, but patterns of behaviour are important. In my current job, I deal with patterns of behaviour on a daily basis in trials. So of course they're important.
And what can a pattern of behaviour, if identified, be indicative of? How would that assist the Crown in the job they have to do?
Well, I mean, it depends what the patterns of behaviour are, but patterns of behaviour, along with the use of inappropriate language, can give an indication into someone's mindset and motivations.
Thank you. And then I think
But as I say, I don't know what the evidence was at the end of the day because I'd stepped down by then. But as a general point, general point of principle, yes, I agree with that.
And in your experience, would you recognise that comparator evidence could be of assistance in relation to an investigation? For example, comparing actions taken with, in this particular circumstance, compared to how actions would be normally taken against a white man?
Of course. I mean, the looked at patterns of behaviour as an example in relation to complaints against the police, whether there was a spike in racial complaints against police officers for Fife when compared with other forces. So these things matter. and is a legitimate line of inquiry, but again, I didn't see the results of the investigation, so I'm commenting on a general level.
Yes. And finally, would you also consider it to be a relevant line of investigation to consider the speed at which officers elected to use force, for example, against Mr. Bio, and consider whether there were any underlying indications or from which an inference could be drawn?
Well, it's very difficult to answer that question without the full panoply of circumstances that the police officers were dealing with. So I don't think you could look at that in isolation. You would need to look at that and around what are the circumstances pertaining to that, you know, that speed time in relation to whatever actions the police are proved to have taken.
And in the absence of overt examples, would it be necessary for PERC or for the Crown to consider the whole circumstances in detail?
Oh, the whole circumstances have to be looked at as part of the investigation into all the circumstances.
And was it any part of your expectation, given what you've told us about your experience and how you viewed the significance of race, was it any part of your expectation that the issue of race would not be fully explored from the very beginning?
No, as I say, front, left, centre. As soon as I heard about it, I knew, and I wasn't alone in that.
We've heard evidence from Mr. McGowan in relation to the steps taken by the Crown after the final PERC report was received. And his evidence is that in light of the circumstances that existed at that time and the work that was done by the precognosers and Crown Counsel, that, as he put it, there were further steps that could have been taken in relation to all reasonable steps to unmask any racist motive. He said there were further steps that could have been taken.
I wasn't there at the time, so I don't know what the further steps were, what he had in mind, but if there were further steps to be taken, these were identified as part of the precognition process, then those further steps required to be taken.
Perhaps we could look at your second statement now, please. And I think you point out in paragraph 2 that you've actually been away from Crown Office now for around 8 years.
Yep.
Could we look at paragraph 4? The Jandu report following the death of Surjit Singh Chokar looked at, inter alia, liaison with the family and questions of how the Crown dealt with racism and racially motivated crime. I was not involved in the Jandu or the Campbell reviews at the time, but I was aware of the findings of the reviews. I was also aware that the Crown accepted the findings and recommendations of the reviews. I was not involved in the implementation of the recommendations of the reports. But at paragraph 9, you do go on to say, paragraph 6, you say, from memory, after the Jandu report, all policies were reviewed to make sure they were equitable and fair. And the prosecution policy was reviewed to ensure that racial motivation was identified and embedded in reporting and decision making. And then if we can move to paragraph 9, please. So I know from personal experience that precognition templates were amended to ensure that precognosers were alive and required to address any issues of potential issues of racial motivation. A section was added to the precognition template narrative. I was involved in designing the templates. I'm interested in exploring this issue with you,
Yep.
but I'm conscious it's now 11:30.
We'll take a 20-minute break.
Okay.
Ms. Graham.
Thank you very much. We were looking at paragraph 9 of your inquiry statement, and if we could have that back on the screen, and you'll remember this related to something known as precognition templates. Tell us what precognition templates were.
Well, a bit of a history to get to explain. In the 90s, what we wanted to do at the Crown Office was to try and improve the quality of precognitions. And precognitions are originally were a bundle of statements. And that then, through the 60s, then developed into assisting Crown Counsel with a narrative taken from the statements as to what the evidence say happened, together with an analysis of the evidence, sufficiency, problems with witnesses, etc., and recommendations. So that's how it developed, 60s and 70s. And of course, what you had was you developed a mix of staff. So you had legally qualified procurator fiscal deputies who were doing precognition work. And you also had precognition officers or non-legally qualified. And when that was looked at, we decided that you had to help and focus the mind of precognosers, in particular precognition officers, as to the issues that required to be identified in a narrative and analysis recommendations. So a group was set up, of which I was involved, precognition working group. Maybe wrong in that, but that's my recollection. And part of the work that was done was to develop templates. So in other words, you're dealing with a robbery case. So you would set a template for a robbery case as to what should be covered in the precognition. Of course, it's not prescriptive. It depends on the case and what the evidence was, but it's designed to help the precognoser as to what the issues are. And I remember, although I've been away a long time from the Crown, but I remember, because I was involved in designing the templates, that motivation, racial motivation, homophobic motivation, etc., was entered into the templates to help precognosers with identifying what the issues that are required to address were.
So it was designed as a prompt, perhaps, to remind precognosers, whether legally qualified or not, that racial motivation, issues to do with race, or other types of protective characteristics, should be addressed in the narrative and analysis.
Not all cases, obviously,
No.
but as you say, it's a prompt and it's like a menu from the template. If it's not an issue in the case, you don't need to address it. But it's, as you say, a prompt would be the best way to describe it.
Something embedded automatically prompts the precognoser to at least consider whether it's relevant to the case they have in hand.
Yeah.
And you have recalled here that those templates did have some entry which required people to consider racial motivation.
That's my recollection. It's a long time
All right.
since these were produced. I've not kept a copy. I'm not with the
No.
Crown. I've been away for a long time, but that's my recollection.
Because in light of this, we've explored the issue, the inquiry team have explored the issue of precognition templates. Let me show you one, which is in relation to the Cap D department. So COPFS 06461. It relates to a standard Cap D report. And this, if we can look at the top, it says criminal allegations against the police division. And if we move down, it invites the following entries to be included: officer complained against, complainer, allegations, linked criminal proceedings, Chapter 24 disclosure category, then move down circumstances. And that would normally be contained within the narrative. And then moving down, analysis of evidence, recommendation, criminal proceedings and malicious complaint, and then reported by. Now, as you'll see, if we go move right down to the bottom, right down, there's no reference in this template of race, none whatsoever. We've gone back to the Crown, who have continued to look for other templates that may have existed. I've been advised this morning that they're not able to find any that include the issue of race.
Well, it's my recollection. I drafted them. I drafted some of them.
Right.
I didn't draft the Cap D ones,
Right.
but it's my recollection.
So if at some point you drafted those with to include race, given your experience, it would now appear that at least some of these templates do not include race. Do you have any comment to make about that?
Well, what I'm talking about from recollection is in the 90s. It's a long time ago and it's moved on. It may have moved on. I'm just speculating. I don't know. All I know is my recollection was that when we were drawing up templates, there was a reference to racial motivation.
At one time, perhaps in the 90s, when you were drafting these templates, you obviously took the view that to have race added into them was something to be done and of benefit. Can you think of any reason why it would not be of benefit now to have race specifically
Of course it
mentioned?
would be of benefit now.
All right, thank you.
Not only race, but all the protected characteristics should be, if it's an issue in the case, then of course.
Would that, in the same way you thought it would be of assistance to precognosers, legally qualified or not, would it continue to be of benefit perhaps to precognosers?
Of course.
Could we turn now please to paragraph 24 of your statement in relation to Simon San? Sorry, this must be the first, sorry, it'll be the second inquiry statement. You're giving examples, and you mention the murder of Simon San, a Chinese delivery driver. And you talk about the accused, John Reed, punched Mr. San, who fell and struck his head on the roadway and died from a cerebral bleed 30 to 40 minutes after the punch. Reed had flown the locus and went to a flat and confessed to another person and used racist language. The question was whether the crime was racially motivated. The answer on the evidence was that it was not racial aggravated. We made sure that the information was placed before the court. We also ensured this was fully explained to the family of Mr. San. So again, you've raised a number of issues here. This was a case which you yourself prosecuted, was it?
I was involved in it. I don't think I presented the narrative to the court on the plea, but I was involved in it, yes.
And you've talked there about the use of racial language, although you mentioned that it was after the actual...
Yeah, I think there was about 30 minutes had elapsed, and it was, from memory, the place he went to after punching Mr. San.
You've talked there about placing the information before the court, and explain the purpose of that.
Well, it says, I mean, there's a number of purposes. Firstly, it's to allow the court to give the court the information so they can take it into account in sentence. Secondly, it places the information in a public domain so that the public, the media, the family are all aware of it, that it's not suppressed, not hidden. It also gives accountability, public accountability, in the sense that this is your assessment of the evidence, and it allows anyone who disagrees with that assessment to challenge it, make it known, challenge it in writing, for example, or whatever.
Thank you. Can we look now at paragraph 31? And we'll have that on the screen. It's a short paragraph. This is where you're asked about training, and you talk here about unconscious bias and racial language. And you give an example in this paragraph and talk about whether it's a direct quote from a witness or an accused. This type of racial language was not to be used. And you talk about the significance of that. And I noticed that in paragraph 24, when you're talking about San, that you also say racist language was used. 2 points about this paragraph in particular. First of all, the example you give, you've spelled out specifically. And I wonder why in one paragraph you've described it as racist language without spelling it out in terms, but in this paragraph you have spelled it out in terms. Was there any reason for that distinction being drawn?
Not really. I can't think of any reason. But I just wanted to make the point that I was seeking to make about the use of such language and ensuring that that language is not used in a precondition unless it's a direct quote, a piece of evidence.
Right. Was this a direct quote from
I think it was from
the case that you're referring to?
I think that was an example I gave, but in the Simon Sand case, I recollect that 30 minutes after the incident, that type of language was used in a conversation to someone else in a house about referring to someone in such pejorative language.
You refer to that and give that as an example of unconscious bias. In this day and age, do you think that is unconscious bias?
It would be both, I think.
Both conscious and unconscious. In any event, it's of relevance to any matters of criminality.
Of course.
And you would expect in a narrative or analysis for that type of language to be addressed.
Of course. But, you know, when you're looking at what is the evidence that the actual crime was racially motivated, so you need to look at whether that could be linked to the actual crime, or is it just racist attitudes and views. So, I mean, there's issues to be addressed, which prosecutors should be experienced enough and able enough to be able to work their way through that.
And I think the key is for those issues to be raised and addressed and considered, regardless of the ultimate decision taken. That's a matter for the Crown. But it would be important for these types of matters, the use of language such as this, to be addressed specifically within the body of the precognition.
Of course.
Thank you. Can I move on to another section of your statement, paragraph 49, which I think is your first statement. And I think in this section, it's called section 4, and you start to talk about, or maybe earlier, above that, there's this section 4 is mentioned, and you start to talk about the post-mortem. There we are, section 4, post-mortem examination and release of Shekubayo's body. And you've given the chair a detailed explanation of the final post-mortem report.
Yep.
Could we look at paragraph 49, please? Overall, it was not possible for the pathologists to be sure what had been the most significant factor in death, and as such, the cause of death was best regarded by them as being sudden death in a man intoxicated by MDMA, ecstasy, and alpha-PVP whilst being restrained. And you say the results of the post-mortem examination would have informed the further investigations instructed by the Crown and undertaken by PERC. We've heard evidence that the final post-mortem report was received on the 18th of June, after the toxicology results were in, and various other investigations of that sort, although the post-mortem itself had been carried out on the 4th of May. Regardless of whether the ultimate proceedings were a criminal trial or an FAI, the Crown would wish to lead evidence, regardless of which forum it was, from a pathologist to establish what caused or materially contributed to the death. Do you accept that?
Yes.
And there were 3 factors named in the cause of death from the final post-mortem report, and they were MDMA or ecstasy, alpha PVP, and restraint. Now, I think in paragraph 49, you say it wasn't possible for the pathologist to be sure what had been the most significant factor in the death. But would you agree that all 3 of those factors, the MDMA, the alpha PVP, and the restraint, were a material contribution to death?
According to the pathological evidence. Just make an obvious, well, I think it's obvious point, that as part of the Crown investigations dealing with the pathology, one of the things, you've got what the pathologist considered contributed to the death of Sheku Bayu. One of the things you've got to deal with is to rule out matters. So at an inquiry or a criminal prosecution, you may be met with, well, is it such and such? Has that been considered? And it's really a duty of the investigator to look at the pathology, identify any possible other explanations and rule that out if possible and get expert evidence on that. And even that would include speculation, speculative causes of death, that type of thing. And then the reason is that you may be faced at, say, a criminal prosecution with a defence pathologist who's putting forward a theory. And if you haven't dealt with it, ruled it out or whatever, then your investigation is deficient. And what you're doing is there's a hole in it which someone else could fill.
Obviously, if the defence pathologist comes up with a new theory, you would anticipate the Crown would be given an opportunity to explore that themselves.
You would.
So in relation to cause of death, you would want to rule out things such as natural disease of some description, such as perhaps an infection or an underlying medical condition.
Yeah.
You would want to rule out a prior assault, such as a stabbing or a head injury or something along those lines.
Yeah.
You'd want to look at removing the possibility of any underlying, as I said, pre-existing condition of some description. And the final post-mortem report actually addressed all of those issues, did it not? And Dr. Shearer and Buhadir took the view that all of those could be excluded as causes of death, and the cause of death for Mr. Bayu was these 3 factors: MDMA, alpha PVP, and restraint. So if it's sufficient for the Crown's purposes to lead evidence at trial or an FAI as to what caused or materially contributed to Mr. Bayu's death, can I ask you in relation to this paragraph, was it not sufficient for the Crown to simply proceed on the basis of the cause of death given by Dr. Shearer and Buhadir? Why was it necessary, in your view, to consider what was the most significant of those 3 factors?
Well, I mean, the case law is such that that is something which will be an issue at the case, to what extent did all three or taken individually. For example, if it's put to the pathologist, well, actually it was alpha PVP, which could have caused death without any contribution from MDNA or restraint, then that's something which you would have to address, and that's what precognition consultation with the pathological witnesses would do, and it may be that you need to get a further opinion in on someone with sort of specialist in a particular area.
And my understanding of the position, and it'll obviously be a matter for the chair, that alpha PVP, for example, could of itself cause death.
Well, that's the issue I'm saying. You would need to look at what is the contribution, could each of these individually on their own without, and that would be highly relevant, I would have thought. Restraint, for example, on its own, highly relevant in relation to the investigation.
Yeah, we've heard evidence that restraint on its own can cause death.
That's the type of thing that you need to investigate and get identify the definitive position so you know where you are in relation to the decision making.
But if it's sufficient for the Crown to simply lead evidence to prove that restraint, for example, was a material cause of death, why did the Crown need to investigate further what proportion or whether it was significant or otherwise? You already have a report saying it is a material cause of death. Restraint was significant. It could not be excluded as de minimis.
Well, you'd want to speak to the pathologist to find out what they meant by that.
Yes. So in terms of your expectations after that report came in, would you have expected either PERC or your own staff to speak to Dr. Shearer or Dr. Buhadir to explore these issues and discuss the post-mortem?
I would.
We've heard evidence from the lead investigator at PERC that that wasn't done.
Well, that's a matter for PERC to answer, but I would certainly expect the Crown to do that.
And we've heard evidence from Les Brown that, in fact, as matters progressed with the investigation, Crown Counsel specifically accepted that cause of death was a given. They referred to a case of Johnson against HMA, which I'm sure you're aware of. It's in the bench book, as I understand it. That what was provided in the final post-mortem report, where restraint was specifically named as one of the factors which contributed to death, and that was sufficient. So was there a need for the Crown to explore this proportion issue further?
I can only speak personally. If it was me as Crown Counsel was dealing with the case, I would want the pathologists conducted the post-mortem to be spoken to and consulted with as to what is the contribution, is it primary, major, what minor, and that, in my experience in dealing with pathology, very important, I would have thought.
Would it matter if it was a minor cause of death, if it has provided a material contribution to death?
Well, legally it would matter, but in relation to the evidence, it does matter. For example, if, for example, you prosecuted police officers on the back of following this, and restraint played a minor part, then that would, if they were convicted, affect sentence, for example, I would have thought. So it is relevant.
Right. Les Brown also gave evidence on the 17th of April that From what I do recollect, was that the Lord Advocate, and I was in agreement with this, he was keen to try to separate out so far as possible whether it was possible, sorry, I'll rephrase that, he was keen to see whether it was possible to separate out the extent to which each of those factors had played a part.
Well, for the reason I've explained.
We've heard that there were a number of reports ultimately obtained by the Crown from a number of forensic pathologists. We've heard that not only was there this report from Dr. Shearer and Booth-Deer, who I should say were not being criticised by anyone else, that there was also forensic pathology reports from Professor Crane, a Dr. Nat Carey, a Dr. Lawler. There were a number of pathologists, and ultimately all said the same cause of death. Subject to one element, they also added in the struggle against restraint as well as the restraint. Can you now envisage why so many pathologists would be required?
Well, in a case like this, which is complex pathologically, it gives confidence. It can flag up issues that haven't been considered by the pathologists, and as you said, I think you said that the additional pathologists had mentioned struggle. So that was flagged up. I mean, I haven't seen those reports, but in my experience of complex cause of death, then it seems to me that it's sensible to get third opinions on other matters,
We've heard evidence that the final forensic pathologist who looked at this from the first instruction until the final report was received, there were a number of communications and reports during that period, but that period took 14 months.
Sorry, give me that again.
So from the first instruction,
Yeah.
there were a number of letters of instruction, but from the first date of the first one to the final report that was received was a period of 14 months.
For the pathology report?
For the final report from the final pathologist. And I wonder if you were concerned in any way about the impact of often instructing experts can take a considerable period of time. I'm wondering for your thoughts about the impact of the delay, the period of time that took, and the impact on the overall investigation.
Well, it's difficult to say, and the time taken, I think, is demonstrative of the fact that it's complex, and there's issues to consider around this. And for me, what I want a thorough report, thorough investigation. I want matters that have been raised to be considered. And if the report took 14 months, then if that's what it took to, for the report to be completed and all these matters to be considered, and as you say, it's not disputed, the original post-mortem and cause of death issued in a report 14 months later, that just demonstrates it was well thought out, I would say, and carefully considered by the pathologist. You've got to remember as well is that the pathologists would be well aware of the profile of this case, and the pathologist would know that it was important to be thorough, to be careful, to get it right.
At the time you were Lord Advocate, was it the normal course of events that when a final post-mortem became available to the Crown, and a 2-doctor post-mortem, that would, the thoroughness and the way that was written, the way that was conducted, would that generally be reviewed by subsequent pathologists to check it was thorough and considered?
It just depends. I mean, the importance of this case and the profile that this case had and the issues in relation to restraint, postural asphyxia, intoxication, all this. It's important, I would have thought, that the Crown has confidence in the original pathologist's view and to get a third opinion on specific issues. I can't see anything wrong with that.
From your recollection, when this final post-mortem report came in, was there anyone in your in Crown Office or yourself to have any concerns about the pathologist? That's Dr. Shearer and
No,
Dr.
I don't
Bahadri.
think. You mean the ability of and experience of the pathologist? Certainly I didn't.
All right, thank you. I'd like to move on to a comment that is in a document which is Lindsay Miller's inquiry statement, SPPI 00428, and this relates to a period after the first PERC report has been received. So it's after the 7th of August. It relates to a meeting which, paragraph 59 please, a meeting which you had with the family on the 12th of August. Now, this is Lindsay Miller's inquiry statement to the inquiry. The first part of my note from the 12th of August 2015 is not a note of a meeting with Mr. Byles' family, but the note of a pre-meet before the anticipated meeting with the family. So there was a meeting with you, I think, prior to meeting with the family. I was present at that meeting along with the Lord Advocate, John Logue and Stephen McGowan. And I have not attributed the comment about the PERC report being a piece of rubbish to anyone, simply noted that it was said, and I cannot now recall whether that was said by someone at the meeting directly or them quoting someone else. I say that because of the use of quotation marks, which suggests one of the attendees at the meeting was quoting someone else. Do you remember who said the first PERC report was a piece of rubbish?
News to me. I didn't certainly say it, and I didn't have the knowledge, and I wouldn't describe it as that. So I've no knowledge of that.
Do you remember from that meeting anyone in your hearing saying that?
No, I don't.
What was your view of the first PERC report?
You mean the interim report?
Yes, we've heard that, I think Les Brown, when he gave evidence, corrected me when I called it an interim report. He said it wasn't actually designed initially as an interim report. He thought that would be the PERC report. But subsequently, because further investigations were required by the Crown, that it then became referred to as an interim report by others.
Well, I understood it to be the interim report.
Did you?
I didn't really have a view on it, to be honest, because it was an interim, whatever terminology you use, it was an interim report, a final report to come in. You would work through the final report once it came in, and you would conduct your own investigation. I didn't have a view on whether it was a good, bad, indifferent report at all.
In your role, did you actually read that first PERC report, or did you rely on information from staff?
A bit of both, actually, but I remember I did read it when it came in.
What parts of it did you read?
I don't think I read the appendices. And I
We've heard that was statements and the like.
Yeah, I didn't read that. I read the actual body of the report itself, with a particular focus on the circumstances which were set out in it. And I think I looked at the pathology as well.
In relation to your expectations after that first interim PERC report was obtained, what How did you envisage matters progressing from that point?
What do you mean from the interim report, to call
From
it
the
that?
interim report. We've
Right.
heard that after that, we've heard evidence from Les Brown that he looked through a number of matters. He then did a letter on the 2nd of September,
Yeah.
detailed letter giving further, more detailed directions to PERC.
What?
To
Sorry, what
pursue.
year was that?
That was 2015.
Yeah. Okay.
So the first, or the interim report, is received. Les Brown, head of CAPD, works on that and does a detailed letter on the 2nd of September,
Yeah.
instructing a number of lines of investigation for PERC to pursue. They then took a period of around 1 year between the August 2015 and August 2016 for the final PERC report to be received.
Well, exactly that. That's what I would expect. The Les Brown experienced, able, been in charge of investigation, preparation from the Crown's point of view to go through it, identify the issues which need to be addressed, let PERC know about them, and these will be addressed in the final report.
And what sort of engagement did you have with Les Brown in relation to the work that was being done during that period, that year?
Not in detail, kind of overview. It would tell me what the issues are, but it's the official's job to interact with PERC at the end of the day to move it forward. The final report comes in, to conduct the Crown investigations, to prepare a case papers, document, precondition, call it what you want, and the identified Crown Counsel to report it to them.
I'd like to move on to an issue regarding instruction of experts. We've heard that PERC were asked to identify experts as part of their investigation prior to the final report being received by the Crown. PERC were to gather in CVs and they were to make recommendations to the Crown as to who should be instructed. And then once the Crown had approved an expert, the PERC prepared a draft letter of instruction which would be checked by Crown Office and then sent off to the expert. And that was happening at the period of time shortly prior to the final PERC report being prepared and submitted. Can I ask you, did you have any concerns at that time about PERC being asked to do this work in relation to experts, particularly medical experts? We've heard evidence that maybe their experience of doing that was limited.
No, because it would be superintended by the Crown, and it's the Crown's decision on what experts are instructed, and the investigators would have an input in that. They made I think it's a detailed letter setting out suggested experts, but ultimately it's a decision for the Crown.
So were you happy that your staff would ultimately take the final view about which experts were to be instructed?
Yeah, I think there's a memorandum of agreement between PERC and the Crown.
Yes, we've heard evidence about that.
Right, I think it may be covered in that.
But were you comfortable that your staff would deal with the issues of who was to be instructed and how they were to be instructed?
Well, that was my understanding. I was comfortable with it.
We've heard that the first couple of experts that were instructed were Dr. Payne James and Dr. Stephen Karch. And they were instructed, actually, the work had been progressed prior to the final PERC report, but they were instructed shortly after that was received. Can we look at paragraph 117 of your inquiry statement? I think this is Lindsay Miller's on the screen. Thank you. 117. there we are. Issues regarding Dr. Stephen Karch. You've addressed this in your statement. The recommendation of this expert was initially proposed by PERC. It would have been done through an assessment of his experience and qualifications. Dr. Karch is a forensic pathologist who is expert in cardiac pathology. He is a fellow of the Faculty of Forensic and Legal Medicine of the Royal College of Physicians in London. He served as a cardiac pathologist in the Office of San Francisco Medical Examiner and is the author of a number of books and has given evidence at a number of trials. Do you remember now, was his name first mentioned by PERC or from someone in Crown Office?
I can't answer that because I can't remember who the genesis of Dr. Karch was.
You've said that it would have been done through an assessment of his experience and qualifications. Who did you expect to carry out that assessment of his experience and qualifications?
Well, the people that were involved in the process was PERC and Les Brown.
Would you have expected PERC to carry out that assessment
To
or
have an
Les
input.
Brown?
To have an input.
Would you have expected them to work together on that?
Yeah. Yes.
And was it your expectation that either PERC or Les Brown would assess independence, impartiality of Dr. Karch and confirm he had no conflicts?
Well, yeah, I would expect that if that information was identifiable. I think there was an issue with him. I think part of it was that he went to the press.
Yes, you deal with that in your statement. I'm interested in his experience and qualifications, first of all.
Yeah.
So who would you have expected to address those issues regarding his qualifications and his experience?
Both Les Brown and PERC
To work together on
worked
that?
together, yeah.
And in terms of assessing his independence and impartiality
It's part of it.
and any conflicts that he may have had?
Part of it, yeah.
Part of it. Now, we've heard evidence, and there is evidence available to the chair, that Dr. Karch was not in fact a forensic pathologist. He'd never conducted any autopsies. And we have other evidence available to the chair that he was being instructed for the purposes of expertise in toxicology. Do you have any recollection of that?
No.
No. So what was your understanding of why Dr. Karch was being instructed?
As it says in paragraph 117, the cardiac pathology.
And why were you interested in cardiac pathology?
I think I need to go back to the original post-mortem report, but from memory it was cardiac arrhythmia and it was referred to it, so that would be an issue. You would need an expert for that, just to look at that as an issue.
That was your recollection of
That's
the
my
reasons.
recollection.
The
But as I
reasons
say,
why.
I didn't have a detailed involvement in that, in the selection of Dr. Karch or looking at his qualifications, independence, objectivity, that type of thing.
Do you remember any part of the instruction being in relation to toxicology or the drugs that were mentioned in the final post-mortem?
I can't recall that. That doesn't mean that wasn't the case, but I don't recall that.
And then if we look at paragraph 120, it's my recollection that there was a misunderstanding that Dr. Karch was instructed on excited delirium. This was not the case. He was instructed on his expertise on cardiology.
It's my recollection.
And so if there's been any suggestion or concern expressed by other witnesses that he was instructed on the basis of his views on excited delirium, does that accord with your recollection?
No, because I was specifically, I remember asking about this because I think it was raised at one of the meetings with the family, and I remember specifically asking, has he been instructed on excited delirium? I was reassured that he wasn't. It was in relation to that area. That's my recollection.
So certainly in terms of your understanding and awareness at that time, you were not seeking to an opinion from Dr.
No.
Karch on excited delirium.
Yeah. Earlier, my evidence, I talked about ruling out things as important as ruling in things. Excited delirium was something that would have to be dealt with, ruled out or whatever. So I remember that, but I wasn't heavily involved in that area. But I do remember saying, look, if this is an issue, you need to look at this. And you need to either rule it out or rule it in. And if you need expert evidence on it, you would need to get expert evidence on it. And the expert evidence may be that, look, this is bogus or whatever. This is not a factor. So that is something that you would want to address.
And if the final post-mortem report from Dr. Shearer and Buhadir ruled out excited delirium and said it's not a pathological condition, and spoke of perhaps being more of a psychiatric condition at best, but not one for pathologists, would you have considered it needed to be ruled out further based on that? I
think I would. I would want to have the confidence, reassurance that that was ruled out.
And if it was possibly considered at that stage to be a psychiatric condition, what sort of expert would you consider the Crown would have to go to do that ruling out exercise?
Well, it's kind of difficult to say sort of in the abstract. I'd need to look at what the information is about psychiatric condition. I would, if I was dealing with it, that particular issue, I think I would take soundings. I would speak to people that I respected. I would take soundings on it and try and identify an appropriate, perhaps psychiatric witness that would speak about it and explain what it is and why that is not a factor in this particular case, so that evidence is available to present to the court. But it depends. It may be it's a combination of both, say, a third opinion in relation to the two pathologists that said it's not a pathological condition, it's a psychiatric condition. I might get a third opinion in that, or on that, and I would also consider whether or not to get expert psychiatric evidence.
And so would the Crown be looking to instruct a consultant psychiatrist or someone along those lines to express a view?
It's a possibility. I don't know. I need to look at, what the circumstances are. And it maybe it's a step-by-step approach. You get further information in, you look at that, and your mind is focusing in on the issue and what particular experts, if any, that would be required to deal with that. But as I say, part of the preparation of a case is to prove what it's not.
And do you remember why Dr. Payne James was instructed? You've talked to us about Dr. Karch. Do you remember why Payne James was instructed?
Don't.
Do you remember anything about him?
No.
Do you remember what his
I remember the
specialism?
name.
The name. Can we look at the letters of instruction that were sent by PERC to those experts? Let's look at Dr. Karch's first. PERC 03434B. See, this is a letter from Dr. Dr. Karch to Dr. Karch in August 2015. This letter actually was sent out just shortly after the interim PERC report was sent. And if we could look at the actual instructions, you see there, letters A to D. Please accept this letter as formal instruction to produce an expert witness report. and documents are attached. There's an expert witness package attached. You'll see that it refers to the physiological effect of the drugs detected in the toxicology sample, individually or in combination on the deceased in the circumstances of his arrest, the physiological effect of the CS Pava spray, individually or in combination on the deceased in the circumstances of his arrest, the physiological effect of the physical restraint of the deceased in the circumstances of his arrest, and the physiological effect of all three in combination. There's no reference there to cardiology or cardiac pathology, or in fact any reference to the heart at all.
Well, that's contrary to my understanding.
And then can we look at the other letter of instruction, PERC 03435A. This is the letter of instruction dated the 10th of August 2015 to Dr. Jason Payne James. And can we look at the instructions also further down the page, please? Looking for A to D also. There we are. Please accept this letter as formal instruction. And you'll see that A to D are in exactly the same terms. Now we've heard that Dr. Payne James and Dr. Karch are different, work in different fields, but the letter of instruction appears to simply cover the same wording and the same questions to each doctor. Do you have any concern looking at that?
Well, I mean, I wasn't involved in it, no knowledge of it. Certainly contrary to my understanding. I mean, I don't know why, or I don't have a recollection of why this expert was instructed.
Right. But in terms of your expectations regarding instructing further experts, would you have expected their letters to be tailored to each particular specialism that they have, and seeking an opinion from each expert within the realms of their areas of skills, qualifications, expertise?
I would, and further I would expect, in addition to a letter of instruction, I would expect conversations to take place with the expert in advance of the letter of instruction. In my experience, if you're instructing an expert, you'd have a detailed conversation with the expert. You'd want to see the expert's CV. You'd do some research yourself to check the expertise of the expert. You would also, again, do some research on whether there's issues with a particular expert. You would speak to the expert, having done that homework. You would identify from speaking to them what their area of expertise is, what they could add, if anything, what they would need if an expert was appropriate, what information they would need, what is the limit of their expertise, and whether or not they would accept the work, timescales and reporting, all these things you would, I mean, there's a process. Wouldn't suggest it's formulaic. Instruction of an expert is an important thing.
Thank you.
And takes time.
I'd like to move on to an issue regarding what was known and described in evidence as a reviewing pathologist. Can I just explain a little of the context of the evidence that we've heard so far? We've heard that there was a forensic pathologist instructed called Dr. Lawler, and there were a number of letters of instruction and reports sent to him, and we've heard evidence from Les Brown that about the genesis of that idea that there would be this reviewing pathologist. And he thought you were the Lord Advocate at the time that this issue arose, and I'd like to ask if you remember this.
So when was Dr. Lawler?
He wasn't instructed when you were still Lord Advocate, but I'll tell you what the evidence of Les Brown is and see if it prompts any memories. So he talked about a reviewing pathologist. This was a course of action that had been, I think, suggested by the Lord Advocate at an early stage in the investigation. And he later clarified that he meant it was Frank Mulholland, as he recollected it, that raised the question of the benefit of having a reviewing pathologist. And he talked about identifying a reviewing pathologist and identifying Dr. Lawler. And as I understood his evidence, it was to have a pathologist come in and review all the reports that had been obtained by the Crown. And I'm wondering if, in light of Les Brown's suggestion that you were the Lord Advocate that came up with the idea and suggested the idea and discussed it with him, do you remember that?
I don't. He wasn't instructed during my time.
No,
if I'd
not at that
suggested
time.
it, he would have been instructed at an early stage, I would imagine. But I don't, when you put it to me, I don't think it's necessarily a bad idea in a complex case such as this, as someone an experienced pathologist who's reviewing matters can identify issues that you haven't thought of, or give information to you and expertise on areas that perhaps you've not considered. So if a sort of overview, third-person pathologist overview was to happen, you would want that person in pretty close to the start. So he's not been instructed. So, and I mean, I've got a decent memory. I don't recollect that. And the fact that he wasn't instructed during my time would support the fact that maybe it wasn't me. But I'm not sort of departing from that. Could be a good idea. It would depend on the circumstances.
Have you, in your experience, used a pathologist in this way as a reviewing pathologist
Yeah.
prior to the involvement with?
Yeah.
You have. Can you explain to us how that
Well,
worked?
cold cases, for example, in cases where the pathology at the time, you have a post-mortem report, and 20 years down the line you're looking at a case. There may be issues with the pathology, original pathology at the time. You might want someone to look at that, not to become an expert witness, but just to look at it, to give you an understanding of what the issues are, could be, what the defects are. I mean, you've got to remember, we all deal with medical evidence, pathological evidence, but we're not pathologists. So it can assist in those types of cases. I've seen it done in in cases of complex pathology, to give you a reassurance. But I mean, I'm just kind of setting out in general terms when it can be of use.
Is that a pathologist who would? Other evidence we've heard is a pathologist could become part of the team to help the prosecutors understand evidence and work through that evidence.
I'm not sure part of a team in the sense of the prosecution investigators, but without instructing that pathologist as an expert witness, it can help to identify, to give a commentary on what's went on before, and identify any issues, any flaws, any defects, anything that you need to address.
Right.
So there is benefit to it, but it depends on the circumstances.
Well, given your own experience of having a pathologist assist, would you expect that pathologist, that forensic pathologist, to then be asked to comment on the opinions of a consultant psychiatrist, a consultant in emergency medicine, or a consultant clinical toxicologist? So separate areas of
It's
specialism.
out with their expertise.
Sorry?
It's out with their areas of expertise.
And would you agree that if it's out with their areas of expertise, it would not be admissible?
What's the point?
What's the point?
But I mean, I wouldn't even do it, ask an expert witness who's, for example, a reviewer, to comment on areas out with their expertise. What's the point?
Thank you.
If I wanted someone to comment on toxicological evidence, it would be a review toxicologist.
And presumably if you wanted someone to comment on toxicology evidence, you would want them to have formal qualifications in toxicology.
Of course. And experience.
And experience. The combination would be required.
Yeah.
Can I move on, please, to another matter? If we look at SBPI 00476, there we are, back to your statement, and paragraph 80, please. PERC and the Scottish Police Federation media releases are, of course, a matter for PERC and SPF. I was aware that the family were concerned and upset at such releases and anonymous briefings, and as a result I wrote to the Chief Constable on 21st May 2015, expressing concern about SPF press briefings. The following is an extract from this letter, and then you quote, "I share your concern in relation to the briefing of the press and agree that it is very unfortunate that the Police Federation saw fit to put information into the public domain at such a sensitive time, and when the facts had still to be established. This was, in my view, unhelpful and caused the family of the deceased considerable distress on the day that I met with them at Crown Office together with their solicitor." Can I ask you, obviously you've expressed concern there about comments made by the SPF. Why did you elect to write to the Chief Constable rather than SPF?
I think from recollection, the Chief Constable had raised it with me as well. So, I mean, the action I took was to put something out in the media. I think you've got the media release.
We'll come on to that.
Yeah, so I didn't see, I thought the Chief Constable was the appropriate person to write to express that.
Did you copy that to SPF?
No, I don't think I did.
Why not?
Not sure.
Was there any reluctance to address matters direct with the SPF?
Not on my part. I wouldn't hesitate in addressing issues, but I can't remember the circumstances at the time, but what was agreed.
At that time, was there any reason not to write to the SPF?
No, I mean, you've made the point to me, and I think it's a good point.
Right. Let's look at some other paragraphs, 99, 100 and 102, and I think you also make comments about media issues. '99. I wrote to the Chief Constable on the 21st of May 2015 expressing my concern at the SPF briefing. Is that the same matter that you addressed in the earlier paragraph at 80? If we look back at 80,
Yeah, probably.
I think it seems to be the same day. It seems to be this. Is that the same?
I think it is.
It's the same. Oh, right, thank you. And then if we can look at 100, 102. I think 100 is just the same quotation.
Yeah.
And you say at 102, I was so concerned about the press briefings and the effect that that was having on the family that I unusually issued a press release on the 22nd of October 2015,
Yeah.
calling for restraint and to allow the Crown and the PERC to get on with their jobs. And I think, is it fair to say you did have concerns about what was happening in the press?
Yeah, I mean, out of the blue, you're reading stuff in the press that about the case, and you know the case was under investigation. It seemed to me to was not helpful. And at one of the meetings, the family expressed their concern, their upset at it. I've never done that before or since. So it indicates the importance I regarded to it. And it did I think from memory, it quietened it down.
And so what in particular was it that prompted you actually issuing your own press release?
Well, to do something about it, to try and kill it. It wasn't just the Scottish Police Federation. There was others that were in the press as well. I mean, I don't know the source of it, but there seemed to be a steady stream of information. It seemed to be the best way to deal with it, to lance the boil, would be to issue the press release that I did.
Did you ever find out who the others were?
No. And I wouldn't be. I mean, how would you find out that with confidentiality of journalists, that type of thing? And I wouldn't even attempt to go down that road. It's not my business. My business is to deal with a drip in the media, and that's why I did what I did.
We'll remain on this topic, but I'm conscious of the time.
We'll stop for lunch at 2 o'clock.